Welcome back to the 45th Perspective, the channel where we dive deep into the stories that actually shape government power, personal freedom, and the future of this country. Today we're talking about a Supreme Court debate that's not making big headlines, but honestly, it should. Because what happened in that courtroom could affect how the federal government works with private contractors, how your tax dollars get spent, and how much leverage the government has in disputes that involve massive overhead costs, lawsuits, and something called the collateral order doctrine. Now I know that sounds technical, but trust me, this is one of those stories that looks like a boring legal issue on the surface, but underneath it's about power, accountability, and government overreach. And here on 45th Perspective, we break things down in plain language. So stick with me, because by the end of this video you'll fully understand why this case matters, why the arguments were so heated, and what it means for America going forward. Before we jump in, make sure you hit that like button, subscribe to the channel, and turn on notifications so you don't miss our next deep dive. And if you want to support the channel even more, you can join our Patreon community. Every like, every comment, every share helps this channel grow and keeps us creating content that cuts through the noise and gets to the truth. I appreciate you being here. Let's get into the story.
On your first point, you mentioned, your friend on the other side mentioned the False Claims Act. That's not a concern?
I'm not entirely sure why it would be a False Claims Act violation to say in a contract, here are our overhead costs, and government, you can accept our bid or not.
Okay, well, I'm sure that'll be used in the future, that representation.
Well, I'm just not sure what Mr. Dre is referring to be honest. In my own discussions with my client agencies, I've been told that these kinds of overhead costs typically are just reflective of background costs, and so presumably GEO might be competing with Core Civic, might be competing with others, and presumably if there were large litigation costs as a result of not having an interlocutory, or I shouldn't use the word interlocutory, but not having an immediate collateral order appeal, that would be the delta, presumably. I guess that would just be priced into the contract. We don't see a hesitance on the part of either petitioner or Core Civic or other private contractors in bidding on contracts in circuits, including the Ninth, which is a pretty large circuit, that don't find this to be a collateral order subject to immediate appeal. As we note, to the extent you're thinking, well, maybe it is an immunity from suit, then you would have to answer the question from Will against Halleck. Is this important enough to warrant an immediate appeal? Is this more like in digital equipment, in Loro lines, in Heike, in other cases? You would have to ask, is this right being under-enforced, was the word Mohawk used? Are district courts getting it wrong a lot? We don't see evidence of that either. All the cases that petitioner cites on its side of the split have ultimately heard the interlocutory appeal and then ruled against the defendant there. So we just don't see it empirically as a large problem.
So the topic at the center of all this involves government contractors, private companies that partner with federal agencies to run services or facilities. Now, these companies handle everything from detention centers to administrative systems, logistics, and more. And as you may know, the government relies heavily on these partnerships. But with that reliance comes spending, oversight, and occasionally conflict, especially when litigation gets involved. That brings us to the Supreme Court exchange that this video is based on. During oral arguments, one attorney responded to concerns raised by another side regarding the False Claims Act. And this is where things get interesting. The False Claims Act is basically a federal anti-fraud statute. It's used to punish companies or individuals who knowingly submit false bills or false statements to the government in order to get paid. We've seen it used in massive whistleblower cases, healthcare fraud, defense contractor fraud, you name it. But in this case, the issue wasn't whether the contractors committed fraud. The question was whether listing certain overhead costs in a government contract could somehow be turned into a False Claims Act violation. The attorney pushed back hard on that idea. He said he simply didn't see how stating overhead costs in a contract could be considered fraud. Contractors list overhead costs all the time. Those are the routine background expenses that go into running an operation, legal, administrative, compliance, facility costs, all of that. And here's the important part. The attorney pointed out something most people don't realize. Government agencies already know contractors charge overhead. It's part of every bid. It's part of every negotiation. Agencies compare contractors on price, quality, experience, and yes, expected risk. If a contractor is likely to face more lawsuits or higher compliance burdens, they factor that in. The attorney emphasized that agencies are familiar with these expenses and accept them as normal, not fraudulent. But here's where the bigger issue comes in. The other side argued that without what's known as a collateral order appeal, contractors could face enormous litigation costs before they even get a chance to challenge whether the lawsuit should move forward. So let me explain what that means. In the American legal system, you typically can't appeal a decision until the case is fully resolved. That means you have to go through the whole trial, discovery, depositions, motions, hearings, potentially years of litigation, before you can appeal. But there are rare exceptions. One of them is called the collateral order doctrine, which allows certain important decisions to be appealed immediately before all the costly litigation happens, but only if certain strict conditions are met. The Supreme Court has long debated when a party should be able to use this doctrine. Historically, it's reserved for major rights, like immunity from prosecution or constitutional protections that would be lost if a party had to wait until after a trial. It's not meant for every disagreement, and that's what this case is about. The contractors want to treat certain decisions as eligible for immediate appeal. The government says, no, this doesn't rise to that level. During arguments, the attorney stressed that even in circuits that don't allow these appeals, like the Ninth Circuit, which is one of the largest and busiest circuits in the country, private contractors still bid on government contracts all the time. They don't back out. They don't refuse to participate. They don't treat this legal risk as some kind of deal breaker. That's evidence, he said, that the lack of immediate appeals isn't causing real-world harm. He also pointed out something subtle but important. In the cases the contractors cited from other circuits, they were allowed to appeal early, but even then, the courts ruled against them. In other words, even when they got what they wanted, the chance to appeal early, they still lost. That suggests the problem isn't the timing of the appeal, but the weakness of the arguments themselves. Now, from a right-leaning perspective, here's where I think the debate really matters. As conservatives, we're concerned about government overreach, unnecessary spending, and legal burdens that make it harder for private companies to operate efficiently. We want transparency. We want fairness. And we want the government to be accountable when it imposes costs that ultimately fall on taxpayers. So when I look at this Supreme Court exchange, I'm looking at it from a patriotic, constitutional perspective. The question for me isn't just who's right legally, but what serves the long-term health of the Republic. On one hand, I strongly believe contractors should not be punished or threatened under the False Claims Act for simply listing overhead costs. Government agencies shouldn't weaponize the law against the very companies they rely on to execute essential operations. If there were real fraud, that would be one thing. But this debate isn't about that. It's about routine business expenses. And on that point, I think the attorney made a strong argument. Overhead costs are not false claims. They are a normal part of running a business. On the other hand, the idea of expanding what counts as a collateral order appeal, that's a slippery slope. We've seen what happens when the courts expand exceptions. The exception becomes the rule, and soon the entire system starts bending under the weight of too many early appeals. Cases drag on for years. The courts get clogged. Justice gets delayed. And remember, true constitutional immunities, like freedom from prosecution, depend on that doctrine not being diluted. So I think the Supreme Court is right to be cautious here. Not every inconvenience is a constitutional injury. Not every legal burden qualifies as something so urgent that you skip the entire trial process. Contractors have tools. They have representation. They have the ability to challenge claims. And they're not shying away from bidding on contracts even in places where they don't get immediate appeals. So clearly, the system isn't collapsing under the current rules. This is where being a thoughtful conservative matters. We have to balance our desire for limited government with our respect for established law. We want efficiency, but we also want constitutional clarity. And we have to be honest when the facts don't support a narrative of crisis. Now let's go back to something the attorney said that caught my attention. He pointed out that agencies already expect contractors to build litigation risk into their contracts. So if a contractor thinks they're going to face more lawsuits because they can't immediately appeal, they adjust their pricing. And frankly, that's how the private market works. Risk affects cost. Cost affects bids. And bids affect which companies get chosen. But that's not fraud. That's economics. That's negotiation. That's how adults do business. So when I step back and look at the big picture, here's my honest opinion. This Supreme Court discussion isn't really about protecting contractors from unfair treatment. It's about trying to expand legal shortcuts so that certain companies can jump ahead of the line when they get sued. And while I respect the drive to shield businesses from unnecessary burdens, I don't think expanding the collateral order doctrine is the right path. We need to reserve immediate appeals for situations where rights would be irreversibly harmed. That's what the doctrine was designed for. And based on everything presented, this case doesn't meet that threshold. But here's the part the media won't talk about. This case does reveal growing tension between the federal government and contractors, especially those involved in sensitive or high-risk services. There's frustration on both sides. There's confusion about what counts as a legitimate cost. And there's growing pressure for tighter regulations. This is a reminder of how deeply involved private companies are in government operations today. Some people see that as a problem. I see it as a necessity, because the government cannot run everything. It needs the private sector. It needs innovation. It needs efficiency. And it needs partnerships that align with national interests. But that relationship only works when both sides respect boundaries. The government shouldn't threaten contractors with fraud accusations over overhead. And contractors shouldn't turn routine legal disputes into constitutional emergencies. So what does this Supreme Court debate mean for the rest of us? It means we should pay attention to cases like this. Because small technical decisions shape how your money is spent. They shape what happens when the government enters contracts. They shape the limits of federal power. And they shape how much leverage the private sector has when it challenges federal agencies. These cases are easy to overlook. They're not dramatic. They don't involve protests or elections or big cultural battles. But they matter. They define the machinery of government. They determine how power flows behind the scenes. And if we want to protect freedom, we can't just focus on the big headlines. We need to understand the underlying systems. So here's the bottom line. The Supreme Court is right to approach these arguments cautiously. Overhead costs are normal. Contractors shouldn't be punished for them. But that doesn't justify expanding immediate appeals in a way that could distort the judicial process. If the courts want to improve efficiency, they should tighten the rules, not loosen them. And from a conservative perspective, we should always prioritize clarity, limited government, and predictable legal frameworks. Because the more predictable the law is, the stronger freedom becomes. Before we wrap up, here's something I want you to take away from this case. When attorneys argue in front of the Supreme Court, they're not just debating legal theory. They're shaping the future of how the government works. They're shaping how your tax dollars get used. They're shaping how companies partner with public institutions. And that affects national stability, economic strength, and even the ability of the government to execute key functions efficiently. This case may not make the evening news. It may not trend online. But it's part of the larger story of who gets to challenge federal authority, how they do it, and under what conditions the courts allow those challenges to happen. And here at 45th Perspective, we'll always bring you the truth behind these overlooked stories, because understanding them is essential to protecting liberty and preserving the principles this country was built on. If you made it this far, thank you. I appreciate you spending your time here. Don't forget to hit that like button, subscribe to the channel, and share this video with anyone who wants clearer, more grounded analysis of what's happening inside the legal system and inside our government. Your support makes all the difference, and it keeps this platform growing. This has been the 45th Perspective. Until next time, stay informed, stay engaged, and stay committed to the values that make this country strong.